Good morning, everybody. We're starting week 7 now. Now we're next to the last full week of the course. And I know that many of you, maybe most of you, are feeling some pressure to get all your work done. I understand that. I've already written a pretty long announcement explaining what we're doing this week, so I'll try to keep this video short. But this week we're going to jump into an entirely different topic, and that is civil litigation. Now here's the problem. Actually, there are two problems with doing this leap. Problem one is that you may not be familiar with the language of civil litigation, so I'm going to try to make you familiar with that as much as I can in the time that we have. And the second problem is that civil litigation has nothing to do with our final project. Nothing at all. So don't try to fit what we're doing this week into what you're doing for your final project. It doesn't fit. The final project is about a criminal case and only a criminal case. So what you'll have to do is what all lawyers have to do. You've got to build a wall in your mind and separate criminal law terminology from civil law terminology. So now that I've scared you to death, let me talk a little bit about civil litigation. It takes a pattern. Once a civil suit is brought, it follows a pattern that's going to look a little bit similar to a criminal case. Here's what happens. First of all, you have parties that are different from the parties in a criminal case. In a criminal case, you have the state or the federal government, which is called the prosecution. And that is the party who brings the criminal charge. And then you have a person against whom a criminal charge is brought, and that person is called the defendant. Well, guess what? The civil terminology is confusingly similar in one aspect. The person who brings the suit is not called a prosecutor, but called a plaintiff. It's just an individual person, not a government. But the person against whom the civil suit is brought is still called the defendant. So you've got this confusion right from the beginning because the same word is used to designate the person against whom the suit is brought, whether it's civil or criminal. But the goal of a civil suit is very, very different from the goal of a criminal action. The goal of a criminal action is to find the defendant guilty of a crime and then punish the defendant. That kind of activity doesn't afford any kind of relief or compensation to the victim of the crime. The victim of a crime is essentially irrelevant to the criminal prosecution, except maybe as a witness. Civil litigation, on the other hand, is entirely about compensating somebody who has been harmed by the defendant. Now here we're talking about very different activities usually than crimes, although there is some overlap. But the main difference is the goal. The goal in civil litigation for the plaintiff is to have the defendant held not guilty, that guilt is not a word we use in civil litigation, but liable. The plaintiff wants the defendant to be held liable for the harm that the plaintiff has suffered. And in order to have that happen, the plaintiff has to meet a burden of proof. Now, we know that in criminal litigation, the prosecution has to prove beyond a reasonable doubt that the defendant was guilty of the crime charged. Beyond a reasonable doubt is the standard of proof in a criminal case. In a civil case, the standard is a little bit lower. The plaintiff still has the burden of proof, that is to say, the person bringing the suit still has to prove it, but the burden is less. The burden in a civil litigation is let me phrase this the best way, the preponderance of the evidence. That is to say, the plaintiff is proving, if we want to reduce it to numerical terms, 51% versus 49% that the defendant is liable. That is a silly thing to do, actually, using those numerical terms. But what I really mean is that the plaintiff has to prove that it is more likely than not that the harm that the plaintiff suffered was caused by the defendant. So right away we have a very different reason to be in court. In a criminal case, the reason is for the state or the federal government to prove that the defendant has committed a crime and then to punish the defendant for that crime. In a civil suit, the reason we're in court is for the plaintiff to prove that the defendant has caused him or her, the plaintiff, harm, and to be held liable for that harm, and here's the key, to pay the plaintiff the monetary value of that harm. Obviously, you can't undo the harm that's been done. That's not within the purview of a court to do. Nobody can do that. What the best that the law can do is to provide compensation to the plaintiff for whatever has been lost as a result of the defendant's actions. Now I'm going to stop explaining this because I've explained it in the announcement already, and this is getting to be a long video. And I also want to mention a couple of other things. You have a discussion board this week that is all about one of the aspects of civil litigation called discovery, and the discovery process is pretrial. The discovery is what the plaintiff and the defendant's lawyers engage in before the trial or before settlement negotiations in order to gather as much information about both sides of the case as they possibly can. The theory being that the better informed each side is, the more smoothly the trial will go, first of all, but even before you get to the trial, the more of a basis there will be for settlement negotiations. The vast majority of civil suits get settled out of court. Very few of them, I think fewer than 3%, actually get tried. So this discovery process leading to a settlement process is a very, very important aspect of civil litigation. Your discussion board asks you to learn a little bit about discovery and then state your opinion as to whether a wide-ranging and time-consuming discovery process is worthwhile. Is it do a sort of cost-benefit analysis on it and then write your initial post in the discussion board. You also have your final project due this week, and I've saved the best for last in this video. You really need to put a lot of effort into combining your milestone 1 and milestone 2 with whatever revisions and corrections you've made to those. But just putting milestone 1 and milestone 2 together is not enough for your final project. Please, please read, print the final grading rubric for the final project and use that as your guide as you write this project. If you don't, what's going to happen is that you'll miss 1 or 2 of the categories because there are so many. And I have to grade you on every single one. And that means that if you miss one of those categories, if you just don't mention it at all in your paper, I've got to put a 0 in there. And every 0 that gets placed into a grading category brings your grade down that much. I really don't want to see that happen. I'm pretty sure you don't either. So please, please follow the rubric as you write your project. Let me know if you have any questions as the week goes on, as you work on your project. You have, I think, until maybe the 14th or 15th, maybe 16th of October. I should have checked that date before I started doing this announcement. I didn't. But you please check it. You have an extended period of time this week to finish the project itself. Please don't wait till the last minute. It's long. It takes a little bit of thought and a lot of critical thinking to put it together correctly. I want you to do well on it, and I feel certain that you would like that too. So let's work together to make sure you do the best job you can on those projects. Ask me any questions you have as the week goes along, as your project goes along. You can do that via the general discussion board so that my answers get published for everybody, or you can do it just with an email to me, and I'll be happy to answer you. Have a great week. Ooh. my screensaver started up. Sorry about that. And I'll talk to you later. Bye.